The list will also be made available on the Corps website after this hearing. Finally, a number of relatives of those who lost their lives in the downing of flight MH17 are also present at today's hearing. I welcome all those present in the name of the court. This case arose from events which began in the spring of 2014 with the occupation and annexation by Russia of Crimea and the arrival of pro-Russian armed groups in eastern Ukraine, in the Donetsk and Luhansk regions. The armed groups subsequently took control of territory in these regions and declared independence from Ukraine, establishing the so-called Donetsk People's Republic, or DPR, and Lugansk People's Republic, or LPR. On the 17th of July 2014, in the context of the fighting between the armed groups and the Ukrainian armed forces, flight MH17 was downed over territory held by the so-called DPR in eastern Ukraine. All 298 civilians aboard were killed, including 196 Dutch nationals. Fighting continued in eastern Ukraine over the subsequent years and regular attacks across the line of contact until 24 of February 2022, when the nature of the conflict substantially changed. The case brings together 4 interstate applications lodged with the court against the Russian Federation under Article 33 of the Convention in respect of the events I've just outlined. Application number 1819/16, lodged by Ukraine in 2014, concerned allegation of administrative practices in violation of numerous convention articles. In the context of the conflict in eastern Ukraine from spring 2014, in 2018, the Chamber decided to relinquish jurisdiction in favor of the Grand Chamber. Application number 43800/14 was lodged by Ukraine on the 13th of June 2014 and concerned the alleged abduction and transfer to Russia of 3 groups of children in eastern Ukraine in the summer of 2014. Application number 28525/20 was lodged by the Kingdom of the Netherlands on the 10th of July 2020 and concerned the downing of the flight MH17 over eastern Ukraine on the 17th of July 2014. These 3 applications were joined on the 27th of November 2020 in the interest of the efficient administration of justice. The joint case was named Ukraine and the Netherlands versus Russia. On the 26th of January 2022, the Grand Chamber held a hearing on the admissibility of the 3 applications. Representatives of all 3 governments participated in the hearing and made oral submissions before the court. The former judge elected in respect of Russia sat on the case for the hearing, but later withdrew. The president then decided to appoint another judge from the court to sit as an ad hoc judge for Russia. On the 13th of November 2022, the Grand Chamber declared the 3 applications partially admissible in a decision that was delivered on the 25th of January 2023. Meanwhile, application number 11055/22 was lodged by Ukraine on the 28th of February 2022 and concerned allegations of massive human rights violation and the changed context after the 24th of February 2022. The government of Ukraine asked the court to indicate urgent interim measures to the government of the Russian Federation. On the 1st of March 2022, the court considered that the military operations in question gave rise to a real and continuing risk of serious violations of the Convention rights of the civilian population, in particular under Article 2, 3, and 8 of the Convention. With a view to preventing such violations, an interim measure was duly indicated on the 4th of March and the 1st of April 2022. Two further interim measures were indicated to the government of the Russian Federation. The respondent state ceased to be a member of the Council of Europe on the 16th of March 2022, and it ceased to be a party to the Convention of the 16th of September 2022. As the Court has already held, a state which ceases to be a party to the Convention is not released from its obligations under the Convention in respect of any act performed or omission before the date on which that state ceased to be a party to the Convention. On the 17th of February 2023, the Grand Chamber decided to join the 2022 application to the Ukraine and Netherlands versus Russia case already pending before it. It also decided to examine the admissibility and merits of the 2022 applications jointly under Article 39, paragraph 2 of the Convention, and at the same time have the merits of the proceedings in the other three applications. The applicant and respondent governments were invited to submit their memorials on the admissibility and merit of the issues raised in this case. The attention of the parties was drawn to their obligation under Article 38 of the Convention to furnish all necessary facilities for the Court's examination of the case before it, and to Rules 44A to 44C of the Rules of Court in that respect. The applicant governments duly provided written submissions. The respondent government did not provide any written submissions. 26 state parties to the Convention were granted leave to intervene as third parties to make written submissions on the 2022 application. The Geneva Academy of International Humanitarian Law and Human Rights, the Human Rights Law Center of the University of Nottingham, the MH17 Air Disaster Foundation, and the individual applicants in 4 cases lodged with the court by relatives of persons who were killed in the MH17 disaster were also granted leave to submit written third-party interventions. The Grand Chamber had a hearing in the Human Rights Building on the 12th of June 2024. Representatives of the applicant governments appeared at the hearing and made oral submissions. The respondent government did not appear. Also, they have been formally notified of the date of the hearing. The 26 intervening state parties were granted leave to make oral submissions at the hearing and delivered a common oral intervention. In addition, the governments of Poland and of the United Kingdom made separate oral submissions. The Grand Chamber adopted its judgment on the 4th of June 2025. I shall give a brief summary of the complaints and relevant facts. In relation to the key legal issues, I shall also provide a brief summary of the Court's main findings before reading out the operative provisions of the judgment. The summary of the facts is not part of the judgment and we will not bind the Court. For a more detailed explanation of the fact and a fuller summary of the Court's reasoning, I refer you to the press release which will be available at the conclusion of this hearing. The full text of the judgment will also be available and may be consulted through the court's internet website. The case concerns first allegations of administrative practices, namely patterns of violations of the European Convention on Human Rights by the Russian Federation in Ukraine beginning in spring 2014. As already noted in the court's case law, the concept of administrative practice comprises two elements: repetition of acts incompatible with the Convention and official tolerance by the respondent state. The government of Ukraine alleged that the Russian Federation were responsible for administrative practices involving violations, among others, of the right to life, the prohibition of torture, the right to liberty and security, freedom of religion, freedom of expression, the right to peaceful enjoyment of property, the right to education, and the prohibition of discrimination. In its previous admissibility decision, the court found in particular that the areas in separatist hands in eastern Ukraine came within the respondent state's jurisdiction for the purposes of the Convention on account of its military presence there and its military, political, and economic support to the separatist entities. It joined to the merits the objection raised by the respondent's government regarding whether the applicant Ukrainian government's complaint of administrative practices of shelling fell within the jurisdiction of the respondent state within the meaning of Article 1 of the Convention. The Ukrainian government alleged that the scale and territorial reach of the alleged administrative practices increased greatly from Russia's full-scale invasion of Ukraine, which began on 24th of February 2022. The case also concerns the downing of flight MH17 over separatist-held territory in the Donetsk region of Ukraine on the 17th of July 2014. In its admissibility decision, the court found that flight MH17 was shot down by a Buk missile fired from a Buk tailor provided by the Russian Federation to the separatists and located in separatist-held territory. The government of the Kingdom of the Netherlands alleged that the downing of the aircraft and the death of those on board, which also alleged that there had been a violation of the provision of inhuman and degrading treatment and the right to an effective remedy on account of the suffering of the next of kin of those who have died. The court addressed first the question of the participation of the respondent state in these proceedings, and notably its failure to provide written submissions or to appear at the oral hearing in June 2024. The court was satisfied that it was consistent with the proper examination of justice to proceed with the hearing of the 12th of June 2024 and subsequently with its examination of the case. As established in the court's case law, the failure or refusal to participate effectively in the proceedings does not automatically lead to acceptance of the applicant's claims. In deciding whether the allegations of the applicant governments were made out, the applicable standard of proof to be satisfied was that of beyond reasonable doubt. The court found, however, that Russia's failure to cooperate with it had made its task in that case more difficult. Russia's lack of constructive engagement throughout the case and failure to participate at all in the proceedings leading to today's judgment breached its obligation under Article 38 of the Convention. In preliminary observations, the court reiterated that the purpose of the high contracting parties in concluding the Convention was to realize the aims and ideals of the Council of Europe and to establish a common public order of the free democracies in Europe, with the object of safeguarding their common heritage of political traditions, ideals, freedom, and the rule of law. The court referred to the widespread condemnation by the international community of the actions of the Russian Federation following the 24th of February 2022. It explained that the transformation from covert to openly acknowledged operations in Ukraine brought transparency to the objectives of the Russian Federation. These objectives appear to be no less than the destruction of Ukraine as an independent sovereign state through the forcible acquisition of Ukrainian territory and the subjugation of any remaining Ukrainian nation to Russian influence and control. The court acknowledged that the events in Ukraine are unprecedented in the history of the Council of Europe. The nature and scale of the violence in Ukraine and the ominous statements from Russia concerning Ukraine's right to exist are a threat to peace in Europe. The court said, I quote, "In none of the conflicts previously before the court have there been such near universal condemnation of the flagrant disregard by the respondent state for the foundations of the international legal order established after the Second World War, and such clear measures taken by the Council of Europe to sanction the respondent states' disrespect for the fundamental values of the Council of Europe, peace, but no less importantly, human life, human dignity, and the individual rights guaranteed by the Convention." The court clarified that its temporal jurisdiction in this case extended no further than the 16th of September 2022, the date on which the Russian Federation ceased to be a party to the Convention. This is why, although the war continues today, the judgment does not examine the compliance with the Convention of events that took place after the 16th of September 2022. Regarding the extraterritorial jurisdiction of the Russian Federation in respect of the allegations, the court examined whether there were evidence that the level of Russian control over areas under separatist control in eastern Ukraine from the 11th of May 2014 had decreased since the admissibility hearing in January 2022, and found that there was not. Russia's extraterritorial jurisdiction therefore continued up until the 16th of September of 2022. The court also found that as a result of Russia's substantial military presence throughout Ukraine after the 24th of February 2022 invasion, its armed force took control of areas of Ukraine. By virtue of this control, the Russian Federation exercised effective control over these areas, which accordingly also fell within Russia's extraterritorial jurisdiction up until the 16th of September 2022. The victims of Russia's military attacks were not in the areas in the hands of the separatists of Russian armed force, but in areas under Ukrainian control. The court found that the military attacks by Russian forces across Ukrainian sovereign territory between 2014 and 2022 were strategically planned with a deliberate intention and indisputable effect of assuming authority and control, falling short of effective control over areas, infrastructure, and people in Ukraine. In planning and in executing its military attacks against Ukrainian territory, Russia assumed a degree of responsibility over those individuals affected by its attacks. These individuals were therefore also within the extraterritorial jurisdiction of the Russian Federation until the 16th of September 2022, meaning that Russia was responsible for the impact on human rights of its military attacks across Ukraine. The court referred to the vast volume of evidence before it, including the evidence submitted by all three parties to the case in the context of the earlier proceedings on the admissibility of the pre-2022 applications. In respect of the allegations of administrative practices, the court said that, taken as a whole, the evidence presented a picture of interconnected practices of manifestly unlawful conduct by agents of the Russian state on a massive scale across Ukraine. These included a practice of military attacks that were variously indiscriminate, disproportionate, and targeted at residential areas in breach of international humanitarian law. These attacks killed and wounded thousands of civilians in Ukraine and created fear and terror among the civilian population. They also caused enormous damage to private property across Ukraine. There were administrative practices in occupied territory of the extrajudicial killing of civilians and Ukrainian military personnel hors de combat, of torture and inhuman and degrading treatment, of forced labor, and of unlawful and arbitrary detention of civilians. These practices began in occupied territory in the Donetsk and Luhansk region in 2014 and increased significantly in scale and gravity after the 2022 invasion. There was overwhelming evidence from the outset of the conflict of the killing of civilians and soldiers hors de combat. After the 2022 invasion, countless bodies were found in previously occupied territory with gunshot wounds to the head, with hands tied behind the backs, or with throats slit. Thousands of civilians were arbitrarily detained, sometimes for years, and thousands of detainees, both civilians and soldiers hors de combat, were subjected to violence and ill-treatment, including beatings, forced nudity, mock executions, cutting off of body parts, electric shocks, prolonged stress positions, and exposure to extreme temperatures. Sexual violence and rape were widespread, and following the 2022 invasion, were used as part of a military strategy to dehumanize, humiliate, and break the morale of the Ukrainian population. The use of rape as a weapon of war was an act of extreme atrocity that amounted to torture. The court also found administrative practices in the occupied territory from 2014 of destruction, looting, and expropriation without compensation of private property, of intimidation, harassment, and persecution of all religious groups other than adherents of the Ukrainian Orthodox Church of the Moscow Patriarchate, and of a justified interference with the freedom to import and receive information and ideas through the intimidation and persecution of journalists, the blocking of broadcasters, and the enactment and enforcement of law aimed at prohibiting and penalizing the dissemination of information in support of Ukraine. The court also held that there was an administrative practice in occupied territory of the suppression of the Ukrainian language in schools and indoctrination of school children. From 2014, Russian became the language of education in the DPR and EPR with a Russian curriculum and Russian textbooks. Teaching staff, children, and parents were harassed and threatened for using the Ukrainian language at school. These measures were extended to other occupied areas in 2022. From 2022, the arrangements for advancing the Russian narrative in schools in the occupied territory sought to enforce the Russification of the Ukrainian population living there, in line with the overall political objectives of separating these areas from Ukraine. The court also found an administrative practice between June 2014 and the 16th of September 2022 involving the transfer to Russia, in many cases, the adoption there of Ukrainian children. There were overwhelming evidence that the transferring Ukrainian children in occupied areas to Russia without consent and facilitating their adoption there became a systematic practice from shortly before the 2022 invasion. In May 2022, legislative amendments were passed in Russia to make it easier for Ukrainian children to acquire Russian citizenship and be adopted by Russian families. These measures were indicative of a systematic program of permanent removal of these children from their legal guardians in Ukraine. Between 2014 and February 2022, the evidence showed the movement of a large number of children back and forth across the border between occupied Ukraine and the Russian Federation. In the context of the overwhelming evidence of systemic transfers from shortly before the 2022 invasion and the transfer of 3 groups of children to Russia in summer 2014, the movement of children across the border between 2014 and 2022 gave rise to a real concern that the systematic practice continued throughout that period. The actions of the Russian authorities lacked any legal basis and were also contrary to international humanitarian law rules on evacuations and on preserving the legal status of children in occupied territories. There were also administrative practices in occupied territory following the 2022 invasion of the transfer to Russia and displacement of civilians and the application of unjustified and invasive screening measures to civilians. And in March and April 2022, of the forcible dispersal by the Russian military of peaceful protests in occupied towns and cities. Finally, the court found that the Russian Federation failed to secure the rights and freedoms in the Convention without discrimination on the grounds of political opinion and national origin, and failed to investigate credible allegations of administrative practices or to provide any redress. As regards the downing of flight MH17, the court found that the missile that downed the flight MH17 was fired by a member of the Russian military crew of the Buck-Taylor or by a member of the DPR. It was not necessary for the court to decide exactly who fired the missile, since Russia was responsible for the acts of the Russian armed force and of the armed separatists. No measures were taken by Russia to accurately identify the intended target of the missile in breach of international human law. The killing of the civilians on board flight MH17 could not be described as a lawful act of war and violated the right to life under the Convention. Moreover, the deployment of the Buck-Taylor in an era where civilian flights were still operating clearly gave rise to an immediate risk to life of which Russia was or ought to have been aware. The failure to take any steps, such as notifying Ukraine of the presence of the Buck-Taylor or closing the surrounding airspace, showed an attitude to the lives of civilians at risk from its hostile activities in Ukraine and breached the right to life. The court further concluded that there was a violation of the procedural limb of Article 2. Any inquiries undertaken by Russia into the cause of the crash were piecemeal, focusing on certain aspects of the incident ostensibly with a view to showing a lack of any Russian involvement and deflecting a responsibility onto Ukraine. These inquiries regularly resulted in the disclosure of information which was later shown to be at best inaccurate or, and at worst, a complete fabrication. The next of kin of those killed were not involved in any inquiries undertaken by the Russian authorities, and were not directly informed of the outcome. The evidence from the International Joint Investigation Team also provided clear examples of Russia's obstructive approach to attempts to clarify the circumstances of the crash. This failure to cooperate had a material impact on the ability of the Joint Investigation Team to conclude its investigation into the involvement of the Russian armed force and senior Russian politicians in the downing of the flight. As regards the alleged violation of Article 3 of the Convention, the court acknowledged that the next of kin of the crash victims had experienced and continued to experience profound grief and distress an account of the killing of their loved ones and the aftermath of the crash. The next of kin were not able to avoid seeing the footage of the crash site and the bodies of their relatives shown very widely in the media. They were forced to witness the lack of dignity shown to the bodies of their relatives at the crash site. They experienced a sense of powerlessness and anxiety that was a result of the limited access to the crash site. Some had to bury the incomplete bodies of their relatives, and in two cases, the victim bodies have never been recovered. Russia's failure to investigate or cooperate significantly aggravated the suffering of the next of kin and led them in a state of uncertainty as to the exact circumstances of the crash. The continuing profound suffering of the next of kin of the victims of the downing of flight MH17 had a character and dimension which amounted to inhuman treatment under Article 3 of the Convention. The question of the application of Article 41 as regards just satisfaction in respect of the breaches established as being adjourned and the future procedure will be fixed in due course. The Court has to join the application lodged by the Kingdom of the Netherlands for the remainder of the case for the purposes of the further proceedings. This will enable appropriate account to be taken on other international developments seeking accountability for the damage and destruction caused by the invasion of Ukraine and for the downing of flight MH17 in the context of the examination of future just satisfaction claims submitted by the applicant governments. I will now read the operative part of the judgment. The Court, 1, holds unanimously that it has jurisdiction ratione temporis to deal with the case insofar it concerns events that took place before the 16th of September 2022. 2, finds unanimously that the complaints by the applicant Ukrainian government concerning events which took place in the territory under separatist control in the Donetsk and Luhansk regions from the 26th of January 22 to the 16th of September 2022 fall within the jurisdiction of the Russian Federation within the meaning of Article 1 of the Convention. Finds unanimously that the complaints by the this is the third point. Finds unanimously that the complaints by the applicant Ukrainian government concerning events which took place in the Russian Federation or in territory in the hands of the Russian armed force from the 24th of February 2022 to the 16th of September 2022 fall within the jurisdiction of the Russian Federation within the meaning of Article 1 of the Convention. 4, finds unanimously that the complaints by the applicant's Ukrainian government concerning military attacks by separatists or by the Russian armed force fall within the jurisdiction of the Russian Federation within the meaning of Article 1 of the Convention and dismisses the preliminary objection raised by the respondent government in that regard. 5, holds unanimously that has been a violation of Article 2 of the Convention under its substantive limb in respect of the downing of flight MH17. 6, holds unanimously that there has been a violation of Article 2 of the Convention under its procedural limb in respect of the downing of flight MH17. 7, holds unanimously that has been a violation of Article 13 taken together with Article 2 in respect of the downing of flight MH17. 8, holds unanimously that the suffering of the next of kin of the victims of the downing of flight MH17 fell within the scope of Article 3 of the Convention and that there has accordingly been a violation of that article and dismisses the preliminary objection raised by the respondent state in that regard. 9, holds by 16 votes to 1 that it is not necessary to examine separately the complaint under Article 13 of the Convention taken together with Article 3 in respect of the downing of flight MH17. 10, declares unanimously admissible the applicant Ukrainian government's new complaints in application number 11055/22, namely A, the complaint of an administrative practice under Article 3 consisting of causing suffering exceeding the minimal level of severity through unlawful military attacks and abductions and forced disappearances. B. The complaint of an administrative practice under Article 8 of the Convention consisting of the forced displacement and transfer of civilians, the involuntary displacement of civilians and prevention of their return home, the application of filtration measures, the destruction of homes and personal possessions, and the theft and pillage of personal possessions. C. The complaint of an administrative practice under Article 11 of the Convention, consisting of unlawful interference with the right to peaceful assembly. D. The complaint of an administrative practice under Article 2 of Protocol 1 to the Convention, consisting of a failure to ensure a right to access education facilities and indoctrination of students. E. The complaint of an administrative practice under Article 14 of the Convention, taken in conjunction with the above articles in respect of the above complaints. F. The complaint of an administrative practice under Article 13 of the Convention in respect of administrative practices in breach of Article 2, 3, 4, paragraph 2, 5, 8, 9, 10, and 11 of the Convention, Article 1 and 2 of Protocol 1 to the Convention, and Article 2 of Protocol 4 to the Convention, and the remainder of the new complaints are inadmissible. Point 11 of the operative part. The court holds unanimously that there has been an administrative practice of military attacks in violation of Article 2, 3, and 8 of the Convention and Article 1 of Protocol 1 to the Convention, and that it is not necessary to examine separatory complaints under Article 9 and 10 of the Convention and 2 of Protocol 1, 4 to the Convention in respect of this practice. 12 holds unanimously that there has been an administrative practice of extrajudicial killing of civilians and Ukrainian military personnel hors de combat in violation of Article 2 of the Convention. 13 holds unanimously that has been an administrative practice of torture and inhuman degrading treatment in violation of Article 3 of the Convention. 14 holds unanimously that has been an administrative practice of forced labor in violation of Article 4, paragraph 2 of the Convention. 15 holds unanimously that has been an administrative practice of unlawful and arbitrary detention of civilians in violation of Article 5 of the Convention. 16 holds unanimously that has been an administrative practice of the unjustified transfer and displacement of civilians and application of filtration measures in violation of Article 8 of the Convention. 17 holds unanimously that has been an administrative practice of intimidation, harassment, and persecution of religious groups, aside from the UOC-MP in violation of Article 9 of the Convention. 18 holds unanimously that has been an administrative practice of unjustified interference with the freedom to impart and receive information and IDs in violation of Article 10 of the Convention. 19 holds unanimously that has been an administrative practice of unjustified interference with the right to peaceful assembly in violation of Article 11 of the Convention. 20 holds unanimously that there has been an administrative practice of destruction, looting, and expropriation of the property of civilians and private enterprise in violation of Article 1 of Protocol 1 to the Convention, and insofar as this practice concerns the destruction and looting of homes and personal possessions in violation of Article 8 of the Convention. 21 holds unanimously there has been an administrative practice of suppressing the Ukrainian language and indoctrination in education in violation of Article 2 of Protocol 1 to the Convention. 22 holds unanimously there has been an administrative practice of the transfer to Russia and in many cases the adoption there of Ukrainian children in violation of Article 3, 5, and 8 of the Convention, and that is not necessary to examine separately the complaint under Article 2 of Protocol 4 to the Convention. 23 holds unanimously there has been an administrative practice of failing to secure the rights and freedoms set forth in Article 2, 3, 4, paragraph 2, 5, 8, 9, 10, 11 of the Convention, and Articles 1 and 2 of Protocol number 1 to the Convention, without discrimination on the grounds of political opinion and national origin, in violation of Article 14 of the Convention. 24. Holds unanimously there has been an administrative practice in breach of Article 13 of the Convention, taken in conjunction with Article 2, 3, 4, paragraph 2, 5, 8, 9, 10, 11, and 14 of the Convention, and Article 1 and 2 of Protocol 1 to the Convention. 25. Holds unanimously that the respondent state has failed to comply with its obligation under Article 38 of the Convention. 26. Holds unanimously that the respondent state must, without delay, release or safely return all persons who were deprived of liberty on Ukrainian territory under occupation by the Russian and Russia-controlled forces in breach of Article 5 of the Convention before the 16th of September 2022, and who are still in the custody of the Russian authorities. 27. Holds unanimously that the respondent state must, without delay, cooperate in the establishment of an international and independent mechanism to secure, as soon as possible and with due consideration of the children's best interests, the identification of all children transferred from Ukraine to Russia and Russia-controlled territory before the 16th of September 2022, the restoration of contact between these children and their surviving family members or legal guardians, and the children's safe reunification with their families or legal guardians. 28. Holds unanimously that the question of the application of Article 41 of the Convention is not ready for decision and adjourns consideration thereof. 29. Joins unanimously application number 28/525/25/20 from application number 8019/16, 43/800/14, and 11055/22 for the purposes of the further proceedings only. This concludes this morning hearing, and I accordingly declare it closed.